Hi everyone, this is attorney Arkady Frekhtman, a New York City personal injury trial attorney, and today we're talking about settlements. How do you settle a personal injury case? And specifically, I wanted to answer two questions that were left in the comments by viewers. The first question asked, it basically said that a lot of lawyer videos talk about the final settlement amount, but they don't talk about the process. What was the initial demand? You know, they asked about the demand letter. What were all the settlement amounts along the way? What did the lawyer ask for in the beginning? And what was the back and forth? And how did it end up at the final settlement amount? And the other question asked whether initiating a settlement conference or initiating any kind of settlement, starting the settlement process, can be taken as a sign of weakness. So let's talk about these questions. I think they're both really good questions. And I think the best way to answer this question is to really break it down in terms of the type of case that the lawyer is handling. So if the lawyer is handling a small case, let's say a case that the lawyer does not want to take to trial because the lawyer feels if they take this case to trial before a jury, they may lose. Or it may not be worth much. That type of case, the lawyer should settle, and the lawyer should write a settlement opportunity letter. I don't like the word demand. I don't know, to me, demand makes it seem like I'm demanding, like I'm begging, and I never want to be in that position, even if I'm handling the worst case. I just like the idea of settlement opportunity. So I'll send a settlement letter on a small case. Let's say I have a soft tissue case, like a car crash, good liability, really soft tissue. The person goes for treatment for like 2-3 months. They might have a bulging disc. They don't want to do anything. They just did very, very basic stuff like chiropractic, nothing else. So, the case is probably worth like anywhere from maybe 10,000, maybe a little less. Some cases even settle for 7,000, 6,000, maybe a little bit more, like 15, 20, but that kind of case. So how would I approach it? If I wanted to get it settled, I would first, make sure my client is done with all the treatment. I would get all the medical records, send a settlement package with the medical records to the adjuster, give the adjuster about 2-3 weeks, call the adjuster and say, look, your policy is 100,000. My client's been treating, how about we settle this? My initial settlement amount is 35,000. And the adjuster will say, oh, okay, I'll give you like 4,000. And then you just kind of try to work it up as much as you can. If you can get them to 10, 12, you probably want market settled. As long as the client agrees and they're happy with that, you can market settled. So that's how I would do it in a small case, right? A case like that. And basically I would start high. I wouldn't start at 10, because if I start at 10, there's no way I'm gonna get more than 10. There's no way I'm probably even gonna get 10. I would start at like 35, 40, you don't wanna start too high, right? Because if you start, give me 100,000 and then they're like, oh, you're asking for 100,000 on a case where you just had 2-3 months of chiropractic visits, acupuncture, massage, nothing else. It's not worth that, right? They have a history of all the other cases. People settle these cases for like 5,000 and less. And a lot of them could be no threshold because they don't meet the serious injury requirement, which is something we have here in New York. And I've done other videos about that. So you see, if you start too high, then you can turn the adjuster off. They could say, oh, forget it. And that happens in other cases too. Sometimes you might have a good case, but you might say, what's your demand? They want to know how much you are asking for. And if you respond and you say, okay, let's start off at like $6 million. Like $6 million, oh my God. We never evaluated the case like that. We thought the case was worth, the most, 200,000, and our first offer is 10,000 because your demand is so crazy, or we're not gonna give you any offer against that kind of a demand. You see, so you probably don't want to start too high. So usually, a lot of lawyers will say rule of 3, so it's like 3 times what they're trying to get. So if they're trying to get 10,000, they'll ask for like 30, 35, 40 in that ballpark. You can go a little higher, like 50, but because you're trying to get a third of what your initial settlement amount is. So your initial settlement amount is like 35, and you're trying to park the case at like 12, 15, that's like your end, right? That's like the end zone. That's what the end result, the final amount that you're trying to get. So that's on the smaller cases, Now on the larger cases, on the cases that are more serious, like the traumatic brain injury, the spinal fusion, even perhaps a percutaneous discectomy case, which is a minimally invasive procedure, but if the policy limits are there, right, if you have $1 million policy or more, and you have a serious injury, and you have good liability, there I would play it differently. What I would do is I would write them a settlement opportunity letter. And if all the information is already present, meaning the client is done with their treatment, we have the liability proven, or we have liability experts, everything is already pretty much done, right? The way I would frame it is I would say, to resolve this case, we believe a fair amount is, let's say, $500,000, right? And then that is the amount that we will accept. And you have 30 days. Now review everything, and please get back to us. Here's my email, here's my cell phone, give them everything, give them all the medical records, give them everything, and just say, look, that's the amount, $500,000. Pay it within 30 days. If you don't pay it, then we will never accept that amount or less ever again throughout the course of the litigation, because we believe in this case. This is a good case. We want to go to trial because we believe we can get more at trial. We're just giving you the opportunity to negotiate in good faith and to protect your policyholder, because that's what you have to do, right? You have a duty of good faith and fair dealing toward your policyholder as an insurance company, whether it's State Farm, Like a Good Neighbor, Geico, the Gecko, or the Allstate, you're in good hands. No matter who it is, they have an obligation to protect their policyholder, and they have to negotiate in good faith, and they have to do what's known as fair dealing. And that means that they cannot put their financial interests of their corporate insurance company, that's already making billions of dollars, by the way, they can't put those interests above the interests of their insured or their policyholder. Because the whole purpose of insurance is this individual is buying insurance for protection. And if an accident happens, they want that protection. And so the insurance company has to protect the policyholder, the person who's paying them monthly or yearly, they're paying policy, whether it's a homeowner's policy, a car insurance policy, auto policy, they're paying for that, right? So the Geico or whoever it is, Allstate, State Farm can't say, you know what, I don't care, I get money from this guy, but I don't want to pay $1 million, even though he's at fault, he rear-ended somebody, the person's got a fusion, I may have to pay $1 million, but you know what, I'm just gonna gamble, I'm gonna risk it. Maybe the lawyer will take $300,000 and I'll save $700,000. Why don't I just play? Why don't I play? Like, you play roulette, you play blackjack in Las Vegas. Why don't I just play with it? They can't really do that, right? Because now what they're doing is potentially this policyholder might get hit for like 10 million. And now who's gonna pay the 10 million? They're gonna say, well, your policy was only $1 million. But the reason he got hit for 10 million was because you're playing games. You're not protecting the policyholder, right? So that's very important. That's known as bad faith law. And in many states, you can open up a policy, and then because they weren't fair and they didn't settle a case for, like, let's say $100,000 on the $100,000 auto policy, because they didn't. So now, if the case goes to trial and the lawyer gets 10 million, now it's open. They have to pay the 10 million because it's because of their risk, right, that this all happened. So that's something. In New York, our bad faith law is pretty weak. I think there's some bills right now in the legislature to create bad faith law in New York. They have it in many states. I hope we get it, but right now it's kind of weak. But anyway, but the point with this is that I would do it differently. I would do it this way. Even in New York, even where we don't have bad faith law, I like to do it this way. Because it makes the path very clear for me too, as an attorney. And I have to ask myself, well, do I feel comfortable sitting with this client at trial? Do I feel comfortable taking a verdict? And if the answer is yes, I like the client has a compelling human story, they are not at fault, they're seriously injured, it's a life-changing forever injury, why wouldn't I want to be with them, right, at trial? Why wouldn't I want to get the maximum that I can for this client? That's my goal. That's my goal as a lawyer. I'm their guide and I can do it. So I say, look, I evaluate the case and I say, you have 30 days. Pay me $500,000 within 30 days. If you pay it, the case goes away. Now, they might have a $5 million policy. Doesn't matter because the case may not be worth more than the evaluation. Now, 500,000 is just an example, right? In a serious case, could be more, it could be less. But let's say I say 500,000 and I say, look, you have 30 days, or I would negotiate in good faith. So if they call me back and they say, look, we don't have 500, but we understand you gave us 30 days. Here's an initial offer of 275. And would you go to mediation? I would, because if I thought the case was worth 500 and they came in at 275, it's relatively reasonable, something close to 300. We go to mediation, maybe we could negotiate a little bit and settle it for 400 or 425. They're being reasonable. But if they just let the letter lapse and they don't respond at all, it means they don't really want to settle. Now, I put right in the letter. So once the 30 days expire, this 500 and anything less is off the table. It'll never be available again. The minimum amount will be like 1.5 million. Now, the insurance company has to take that into consideration. Either they settle with me for the 500 or they negotiate in good faith. Maybe they can get it a little less, right, like 425. Or if they say no, then they let the letter, the 30 days lapse. Now, fine. We're just going to go to trial. We're going to prepare it. We're going to do all the finish up discovery, depositions, put it on the trial calendar, take the verdict. And now the minimum amount I would accept is 5 million, or I'm sorry, 1.5 million. And it might keep going up, right? Because the more work I have to do on the case, the more I would then ask for, and then it'll just keep going up. So what I'm essentially doing is I'm flipping the script on them. Instead of playing their game where they say, oh my God, you're asking for 1 million. It's not worth 1 million. Forget about that. We have just 25,000. Why don't you ask for like 150? And then maybe we'll come up a little bit. See, what they're essentially doing is, if it's like 1 million policy, they're asking you to just forget about 900,000, right? Just give it to them. And now negotiate off that little like 100,000 and then please be like a beggar. And then they don't want to give you anything, and then they want to park the case. They want to settle the case for as little as possible. And what we're doing is we're doing the exact opposite. We're flipping the script. We're saying 500,000 is fair and reasonable right now within 30 days. If you don't want to do it, that's fine, but it'll never be available again. Now it'll be 1.5 million. And if I have to do an opening statement, it might be 3 million. And if I have to go all the way and speak to a jury and tell the jury what is civil justice in this case, I'll tell the jury civil justice is over 5 million and you only have a 5 million policy, you might get hit for beyond the policy, and who's going to pay anything extra? You're insured, this poor little old lady that you're going to say, because that's another thing. What they like to do is at trial, they like to say, oh, you can't mention insurance at trial. So they want to make it seem like this policyholder, right, this individual who's driving the car is going to be liable for all this money personally, which isn't true. Everyone knows it isn't true, but we can't really say insurance because then it'll be a mistrial. It's not allowed. I mean, there are certain ways that you could maybe try to, intimate, but you can't really even, I don't think a lot of judges would even let you do that. Say something like, we're not really suing poor Betty Simpson over here, the little old lady. She's not going to be liable for anything. It's really, could there be some corporate interests? Could there be someone else involved? But I don't even know if a judge would let you say that. So you see what I'm saying? So the point is that this is a better method, I think, with respect to larger cases. Because with the larger cases, you don't want, even if you start out high, essentially what the insurance companies will do is they'll try to whittle you down. And then, if you start too high, if it's like $6 million, oh, they'll make fun of you, like, oh, you're crazy. And then, so this is just a better way. It's like you don't waste your time with all this nonsense. And then you just have to stick to your guns. The important thing is to stick to your guns and just be firm and just say, look, 500,000. The case is worth 500,000. Pay me within 30 days. If you don't pay me, it'll be 1.5 million and it'll go up from there. And you'll never have this opportunity again. And you have a duty of good faith and fair dealing to your policyholder because you know that your policyholder has a $5 million policy. So I'm essentially resolving the case for 500,000 and you can keep $4.5 million. Look at it that way, insurance company. You're keeping $4.5 million. But if you say no, I'm coming for the whole thing. So it works. They always do something when I send these letters. They're known as Running with the Bull letters. There was a book known as Running with the Bulls written by Nicholas Rowley, one of the lawyers from actually Trial by Human. This t-shirt I'm wearing, very, very good. He's like one of the main lawyers that started the Trial by Human. And it's a really, really fascinating book. I recommend every lawyer get this book and read it. But the point is that with this system, what you're essentially telling the insurance company is that you're not afraid, you're going to go to trial, you're willing to settle the case for a fair number now, and if they don't want to settle it, then fine, we're going to go to trial. And so, but you just have to stick to your guns. You can't say it and then, try to bluff them or whatever, like in a poker game, and then later call them and be like, oh, my demand is 200 now, because then they're gonna be like, oh, this guy's a BS, he's not real, and then they're never gonna, settle with you again. So you have to have an actual record of jury verdicts. You have to be going to trial, getting jury verdicts, getting high settlements, and that is the best way to do it. So to answer these questions, the first question was about how many back and forths and all this. I think in the smaller cases, it's fine. I don't know exactly how many back and forths, it all depends, but definitely do the back and forth, start high, at least 3 times what you're trying to get with the small cases. With the larger cases, if you have a serious, like life-changing injury, I would just give them an amount that you think it's worth, talk it over with your client, make sure it's an amount your client agrees to, and just send that letter. And every time I send that letter, the Running with the Bulls letter, the settlement opportunity letter, something happens. Either they tender the policy, they pay the full policy limits, they give me an offer that's very, very close or very much higher than they did before, and we settle the case. If they're not going to settle, if they dig in their heels, what they end up doing is they end up firing the lawyer who's representing the insurance company and hiring a new lawyer. And sometimes the partner from the law firm will call me and say, what are you trying to do with this letter? Oh my God, it makes their head explode. They really don't like these letters because you're essentially calling them out, right? You're essentially just telling the truth. You're telling them, hey, you guys are not playing by the rules. You're committing bad faith. You're not taking your policyholders' interests in the same position as the insurance company's interests. But when they hear it, because there's all these internal things going on too, right? The lawyer is evaluating the case and he's writing reports to the carrier saying, hey, I think this case will settle for $100,000. I think, I'm going to be a hero. I'm going to settle this case cheap. I'm going to save you money. So all of a sudden your letter comes in and they're like, wait a minute, you said you were going to settle this case cheap and this guy's saying 500, you said 100. How could this be? See, so now they have to reevaluate and they have to change everything, and it just blows everything up. So it's like, it's really good for plaintiffs' attorneys. Anybody who's passionate, anybody who's aggressive, it's very good because it really it's like ba-boom. It just blows up everything in the water, and then they don't know what you're going to do. So I recommend it. It's good. If you are going to try the case, that's the caveat. You have to be sure that you're willing to take the case to trial, because if they don't pay you the number, then you take the case to trial and then you hit them in trial. So I hope this has been helpful. This is just a little bit of a dichotomy, right? How I handle settlements. And it's up to the lawyer together with the client to figure out which bucket your case falls into. If it's relatively smaller, like soft tissue, no surgery, no fractures, you can do the first one. Or if it's relatively limited policy, like a 25 policy, 100 policy, do the first one. If it's a bigger policy, if it's a $1 million policy, more serious injuries, surgeries, fractures, anything life-changing, forever injuries, do the second one. Send them the opportunity letter, tell them, hey, you have 30 days, you don't want to pay, fine, it's great, it's better for me. I'd rather go to trial. I'm a trial lawyer, that's what I love to do, but I'm giving you this opportunity to settle the case earlier. So, I think that's the way to approach settlements, and we've had really good results. Just like off the top of my head, I could think of so many. Even just last week, I think we settled the case. We just settled the case again. I sent one of those Running with the Bull letters, and like a week later, they called and we settled the case, and it was a significant case. It was $300,000 or more on a car crash. So it works. And this is in New York, where we don't even have the bad faith law. If you're in a state that has bad faith law, like for example, I think California, Washington State definitely has it, Florida has it. I believe Texas has it too. A lot of states have bad faith law. If you have the bad faith law, you could open up the policy, then it's even more devastating because now the policy is open and you can pretty much get anything. Open means there's no ceiling, right? You could have a $25,000 insurance policy. You tell them, hey, tender the 25 because these injuries are so bad. And they say, you know what, no, or they're just lazy, or they let it lapse. If you do it the right way and you hit all the prongs, and he tells you the prongs in the book, but if you hit, I think it's like 9 or 10 different prongs. If you hit all the prongs in the letter and you do it properly, now the policy is open, go to trial. I think there was an example in the book where it was like a $50,000 policy, and he wrote a letter and he said, I would settle this case for 50, and it was like a traumatic brain injury case with very, very serious injuries, but it was a contested liability. And they said, no, we're not even going to pay the 50. He said, fine. He took it to trial. I think he hit like 44 million, and they had to pay the 44 million, which is just crazy. But you see how you could really, when the policies are open, it's very good. So I hope this has been helpful. Let us know what other questions you have, and we are here for you. Okay, have a great day, and we'll talk to you very soon. Bye-bye, everyone.